Hello everybody. So this is experimental. I've got one chance to do this. I can't edit it, so if it goes wrong, well, I'll just have to keep going. It is a talk on money laundering. We're going to try and do this annually. I'm the money laundering officer. Tom is a deputy. Note also that Adele knows an awful lot about this if we're not around. I'm particularly talking about the fact that there are new money laundering regulations 2017 that have come out, and what's most useful for all of us is that this thing here is now the Bible. Only 3 or 4 weeks ago was it ratified. Anti-money laundering guidance for the sector. If you put that into, I've got a copy obviously you can always ask me for, 156 pages of fun. If you put it into the Law Society website, they've got a copy there. So this is now the thing you go to when you're worried about stuff. E.g., what do we do with trusts, with companies and so on in terms of ID? So what is the issue? The issue is the government see us solicitors as being the devil's spawn and the key to facilitating crime. So we do have to be wary. Actually, we are particularly vulnerable to money laundering in a way because we do good quality work that's not always done in the country, but city quality work sometimes in certain areas, but we don't have reams of people like they have in the city who sort of look after all this sort of stuff. So we do have to be, I'd say, more careful than most people on this subject. Right, definition of money laundering: the process by which the proceeds of crime and their true ownership are changed so that they appear to be from a legitimate source. E.g., actually as small as accepting cash when you have your windows cleaned, because the real reason for that, of course, is that they don't want to put it through their bank accounts. There are 3 bits of it: placement, layering and integration. I'm not going to go through those. It's all to do with people getting money in the system, then layering it so there's lots of different transactions between where it came from to make it look clean so that it can't be traced back. These money launderers are always worried that if somebody gets caught, it'll eventually get back to them and they'll be caught. So that's what it's all about: payment, layering, integration. There were loads of older acts that were all brought into one piece of legislation modified on 26 June 2017. It only applies to activities where there's a risk of money laundering happening, land transactions, particularly in this firm. So technically it wouldn't apply to litigation, wills, that kind of thing. However, we do apply ourselves this to everything we do, because sometimes you can easily stray when doing a will or maybe doing a matrimonial into something where we are caught by the money laundering legislation. So better to cover it all, which is why everybody does it, whatever their subject. It's important to say it's still risk-based. So you have your sort of 90-year-old who hasn't got a passport, and as long as you sign it off for me, I'm normally going to say that's okay. So there are the systems, but the systems aren't the thing. The real thing is actually in your head, thinking through situations and making sure that you don't think there's any money laundering going on here. So, for example, if somebody wants a £5 sent back to them, you're not really going to worry and think they're laundering that amount of money. It's always a matter of engaging the brain with these things. We have to have and have got a firm-wide risk assessment policy to identify money laundering and terrorist financing threats. Hence things like the car reform and all the rest of it that you have to complete. Don't forget, when you do the car reform, don't just pre-fill it and spend half a second. It takes half a second to pre-fill it and not think about it. It only takes 30 seconds to fill it and actually think about all the stuff you're signing off. Customer due diligence next, CDD. So when do you do it? You do it when you're establishing a business relationship with somebody or doing a real property transaction. You also have to redo it, in effect, if you're suspicious or you doubt documentary adequacy. So it's an ongoing thing, and that's probably the most difficult thing. You might, do somebody's ID and be happy, and then something will happen a little bit further along that will make you worry about whether it was proper in the first place. Then you kind of have to redo your thinking about whether you've properly CDD'd the person. So when do we do it? We still open the file. There's this all this business about when do we open the file. A lot of firms won't even open a file until they've satisfied them, which is why conveyancing transactions are often delayed at the beginning. We do, and do it as quickly as possible. The danger is that we do stuff, we let it stretch on. So you've got to be very careful about that. Certainly don't do any money transactions until that point. And you shouldn't do any substantial work, just send off initial letters. You shouldn't really be requesting and receiving search monies, for example, on property matters until that time. What do? You identify and verify the client from a reliable, independent source and must understand the beneficial ownership structure, plus identify the purpose of the business relationship. Why it's really important at the beginning of a transaction actually to tell people what you're doing for them. You've got to understand what you're doing. If somebody wants you to do something you don't really quite know why they're doing it, then that's a warning sign. How do you do it? Well, it's already on the system. You know what we do at the moment. So if it's already on the system and it's less than 3 years, you don't have to do anything new. If it's new or the ID is out of date, new client or ID out of date, scan passport and utilities to do the electronic test. And if you don't see them, most of the time we will see them. You really should try to see them. If you don't, you get an original signed copy of the passport, but with a true likeness from ideally another regulated person, like an accountant, a lawyer, a bank person, and if you're desperate, an estate agent. And you must complete the forms on the computer and on the file. Third parties can do the lot of this for you. Won't often do this, but if it's really possible for you to see somebody, it's called reliance. Unusual, as I say, and there are specific requirements, so do ask me, but it can be done completely by a third party, like a broker, for example, who would always have to do it. Ongoing monitoring, I've spoken about that. Remember in probate to ID those sending funds to, I've written here for some reason. So looking at one or two particular areas, that those are individuals. Partnerships, you usually just treat them as private individuals, unless it's a very reputable, gigantic partnership, maybe that's sort of registered on a national sort of level. Companies, constitution and formation papers, because that is the company, that's what makes you know it exists, plus 2 directors, particularly the person who's instructing you. So if there's 15 directors, you don't have to do all of them, but 2, but definitely the person who's instructing you. And you also have to check out the beneficial ownership. Private companies, overseas companies, hackles up, they're much more dangerous. So if you've got a company, from the Virgin Islands, it's a real issue doing CTD. In fact, this is the risk-based thing. If it's a local company you know well, you see them in the paper the whole time, you just do the very basics. If it's a British Virgin Islands company, new client, why have they come to us down in mid Somerset, then you'd really go to town, and you may even refuse to act, in fact. Trusts cannot be clients. The client is actually the settlor or trustee or the beneficiary. So who needs to be identified as complex? There's quite a lot of it in that booklet. So by all means come back to that. There's other subjects like charities, churches, clubs, pensions, etc., which I've got details of if you're not sure, but it is covered by these things. Don't forget you need to work out and record beneficial ownership on a risk basis. Again, somebody who owns more than 25% of a business, I've got details of that if you need them, but I think you're fairly aware of that. Also, there's something called simplified due diligence if it's kind of a bleeding obvious, like say you're acting for the government, but actually I think it's too risky to produce a new category, so let's not worry about that. But there is enhanced due diligence where you have to have higher standards. And actually it's people you haven't met, it's politically exposed people, UK now, not foreign actually, strangely. You just have to use your common sense really, but if you look at the book or come back to me to ask if you have a pet, what you do. Right, next, source of funds. Always use the form. The form has been modified, I expect Karen will have been told you about that, because there's a new concept in a way of 2 distinct things. Firstly, the source of wealth. Secondly, the source of funds. So the source of wealth is how generally did a person like this afford thing like that. So if somebody sort of who you know to sleep in a car in Durston Drive or something comes and says he's buying a manor house, that you have heckles up in terms of source of wealth. Source of funds is actually which bank account did it come from, and so on. So really, in the past, I think we've concentrated on the source of funds. We need to think more about source of wealth. As ever, it is risk-based. Now, the offences, I'm not going to go into the offences exactly. We did it last year, I think, but there are good detailed notes if anybody's fascinated by it. Any issues, ask me. And also there's all these issues of sort of making a disclosure. If you're suspicious about anything, come back to me, and care not to tip off. Again, have a word with me, and we'll take you through that. We probably do 1 a year disclosures. I've done one in the last 2 or 3 months. This is the thing where you write to the police or email the police, and they, if you don't hear from them within a couple of weeks, you can continue. It's always interesting and horrible, but there we are. Right, money laundering warning signs. These are things just to look out for. They may not be a sign of anything, but don't forget the main thing we have in terms of money laundering isn't all the forms and isn't me talking to you or anything like that. It's you actually engaging the brain as to what's going on in the transaction. Particularly maybe in commercial, residential, not so much, but we have had residential money laundering cases in the past. So what you look at, secretive clients. Why are clients being secretive? Some people are naturally secretive, but often it means they've got something to hide, so watch out for that. Unusual instructions. Somebody asking you to do something that's outside your area of knowledge. Things that change suddenly in a transaction. Things that there's no reason to do. I've probably told you before, I had a case where somebody kept saying we're just changing our beneficial interest, but never explained to me why that was, and it turned out to be a fraud. Something that's very complex. People try to hide things by making it complex sometimes. Using of the client account, where really there's a little minor transaction, but they're using the client account. That's what they're really doing rather than a transaction. Direct payments, collective investment schemes, anything to do with that, don't touch, I would say. So all these sort of warning signs that we've talked about them before, to be careful of. There's a good list of them in this anti-money laundering guidance for the legal sector if you want to look at that. Now, solicitors' checks in conveyancing. I don't know if I'm going to cover that. This is basically on a sale in conveyancing, you use standard letter 11, or it is written here, and also the bank check, i.e. Law Society Finders Solicitor, SRA, Solicitor Check, Google, and so on. Maybe we'll do further clarification of that, but it seems to me that everybody seems to be working it okay at the moment. On a purchase, you use that standard letter 5, or not actually standard letter, but the bits of it that you need. Basic, lender exchange, if possible, and the account checker, whatever it's called, if that fails. We're finding we're doing hardly any account checker because normally they're on lender exchange, and that's okay. And don't forget you need to do one just before completion as well on that. I think that's it. I tried to keep it short because I really think it's a bit dull watching people on videos. It'll be interesting to know what you think of this. If there's any questions come out of it, or if any of you would like a full copy of this exciting thing, just let me know and I'll send you one. It is very good. If you could spend 20 minutes just reading through it, I think you'd feel more certain about everything. There we are. Thank you very much. I'm going to switch myself off.
Hello, I have drawn a short straw and I need to talk to you guys about the General Data Protection Regulations which come into force on the 25th of May this year. So basically it's a set of regulations which have been brought in to govern how companies store and look after their information essentially that they collect on their customers. So obviously this applies to the big corporates, but it does apply all the way down to firms such as ours as well. So really, as a firm, as a business, it's going to affect us twofold. First, in terms of what we actually do day to day in terms of our client information and how we store and save our clients' data, and then secondly also as employers as well, so in terms of the information that we hold and look after in respect of our staff. So it probably makes more sense if I talk initially about how this is going to affect us in terms of day-to-day running of the business, and then secondly I'll talk about the staff implications of that. So the data protection policy is now a policy that we have prepared, which is available on our website. It will be shortly, and it's also going to be saved in the practice manual, which clients can review if they have further queries, if they're that way inclined, to find out exactly how we hold and store the information. And there is also going to be reference to this new policy in our terms and conditions, which again are being worked on at the moment. I'd imagine they're going to be ready in the next couple of days, and then we'll be using those updated terms and conditions from here on in. There's probably going to be a message which is going to go out at the end of all correspondence, similar to our Christmas opening hours message, just in a box at the end of all correspondence, just confirming that we now have this new policy in place and that clients can view it online if they wish to do so. So really what this policy is saying is obviously what information we collect and how we store it. So in terms of our clients, actually it's not, these regulations aren't really affecting that much. We're still going to be doing the standard money laundering checks that we would do as and when we open any new file, basically what we do need to be aware of is we need to be far more stringent in making sure that we accurately collect that information and then store it on SOS, so that we're not asking clients each time we open a new file for them to pop back into the office and provide all of the necessary ID. We need to really try and minimise the amount of information that we're storing hard copy on files in terms of client ID. So it is making sure that really it's just a case of new clients or clients where the ID has expired that the hard copy information is being collected, but otherwise we should just be able to go from SOS. As I say, John has obviously protected our servers. We're up to date with all of our antivirus bits and pieces. So in terms of actually how we're storing the information, that's not going to change in any way because we already have a secure system. Obviously, if we didn't, then these regulations would be a huge overhaul for us, but thankfully there's not that much of an issue in that respect at all. Obviously, a few years back as well, we scrapped the database we had where ID documents were being scanned and stored that way. So it's not really actually going to affect the information that we're receiving and how we store it. That said, obviously, we are no longer asking members of staff to send out the client questionnaire that we have been sending out until recently, mainly because actually a lot of that information we don't need. We should only now be requesting information that is specifically needed on that particular transaction. So there's no need to go above and beyond. We shouldn't be asking for national insurance numbers, etc., if it's a sell transaction where we're not going to need those. So it's just basically having a common sense approach and just minimising the amount of information that we're collecting from clients, so it's only what we need and when we need it, really. So also in terms of how long we're storing information, that's not really going to change either. We're still going to be storing for 15 years, mainly because that's what we're required to do by the Law Society. And again, clients are going to be made aware of that through the terms and conditions and this data protection policy in any event. So that's not really changing. I suppose what we need to be aware of is that we need to be, as I say, far more stringent with the information that we're collecting the information that we're collecting, but also how we are storing that as well. So it really is a case of we need to make sure that if we do request for a passport documents to be copied, for example, that they make their way onto the file as quickly as possible. They're not left behind at the photocopier, that they're put into the file and correctly stored. It means as well we shouldn't be taking excess paperwork home with us in the evening, so if anyone works from home, we should really only be taking back those parts of the file that we require. If you're a fee earner that uses your phone for terms of emails as well, again, it's just taking practical steps to make sure that we're doing what we can to minimise the risk of there being a data breach by making sure that your phone's password protected, for example. So we just really need to do what we can, just take a practical approach really. However, if there is a breach, so for example, if you were to email the wrong person and somehow provide a separate client's account details, bank account details in that email, then obviously that is a very high risk breach, which we then need to report to the Information Commissioner's Office. So there will be forms again updated relatively soon, I would imagine, in terms of the breach forms that usually go to Bruce or Richard. We'll continue to use them in the same way, but there's probably going to be an extra level of red tape, really, I suppose, that's in there, so that if there has been such a breach, I then, as the data protection officer, will need to consider whether that's something that we need to report on to the Information Commissioner. We only have 72 hours from a breach occurring for me to report it, so it is just a case of obviously common sense. If you know you've done something, you've emailed the wrong client and client information has gone to the wrong source, then obviously we need to make sure steps are taken relatively, well, as soon as possible really, to try and minimise that risk and report it. So, and it is a case of, even if you think that the risk is relatively small, still reporting it in the usual way, but so that obviously if we ever receive a audit from the Information Commissioner's Office, we have details showing that we have a system in place and how it works. So, I mean, those are the practical steps really, and the main implications that we're going to have as a firm. The regulations also provide the ability for clients to put in a subject access request or an information request. So essentially they can ask to find out what information we hold in respect of them, and they can also ask us to delete that information as well. So if you ever receive a request like this, or something that sounds like it could develop into something like that, then it's best to just send it to me. I'm going to be the person that deals with that type of query. So if you basically forward any queries that you have in that respect to me, and I can then deal with them. Again, we have a month to respond to the client and provide them with all of the information that they're requesting. And although it sounds like a great deal of time, obviously it can take quite some time, especially if we have old files at store, etc. So it's just a case of letting me know as soon as possible. So that's really the impact that those regulations are going to have on us as a firm. As I say, it's not really changing anything day to day in terms of what we need to do. In theory, from what we're doing already, we just need to make sure we're taking a practical approach. And if you have anyone who wants to know what information we hold in respect to themselves, then forward them to me. So that's how it affects us as a firm in respect of clients. Then the other side of the coin is obviously in terms of how it affects us as employers as well. So again, really just considering what information we hold in respect of our staff, what we need it for, how we use it and how long we store it. So really, again, it's mainly going to be in terms of each member of our staff. It's going to be things like contract, the contract itself. We're going to need your account details to make sure that you get paid. And obviously Louise is doing this new system, which I know she's been emailing about previously, which is actually tying in with these new regulations to make sure that, again, we're only requesting information that we need from you, nothing above and beyond, and obviously it's then being stored in a secure software that we're investing in. and then really it's going to be a case of storing that information. Again, we can actually store it up to 7 years after an employee leaves the company, mainly because obviously they could be asking us for references, etc., which we may need to refer back to them on file, and also in case there's any form of breach of contract aspects. For example, if they were to bring a claim against us, we need to make sure that we have a copy of their contract and some of the information, including details as to where we made payments and how much those payments were, so that we have that information on file if we ever need to get into that type of dispute. Not that thankfully it really happens to us. Touch wood. So that's it really, I suppose. The general data protection regulations is essentially more red tape, I'm afraid. Nothing particularly exciting, but it just means we have to be really stringent with the type of information that we're receiving, what we're asking for, how we use it, and obviously, as I say, if there is any form of breach at any stage, then it's just a case of letting me know as quickly as possible. So if it's a high risk, obviously if you sent someone's bank account details out, then obviously let me know as quickly as possible. And if it's just a normal breach, perhaps we've used the wrong email address, etc., then it's just a case of doing the standard form that you would usually do, and that will end up with me in the long run as well. And that's it. You will all, I'm afraid, be asked to watch a webinar, which hopefully will be far more succinct than this rambling monologue of information you've just received from me. But again, it's just going to be a bit more training that unfortunately we need to ask everyone to watch. And again, that DVD will be coming around and being circulated before the 25th of May when these regulations take effect. But any particular queries, then obviously please do let me know. Thanks very much.
Hi there, I'm going to run through a few admin bits and pieces. First is a reminder to record your voicemail on a daily basis using the date, and as much information as you can without obviously making the message far too long. If you're in meetings for a couple of hours, then you can say that. Secondly, the breach forms, they're about to be updated to take in the new data protection regs, but do please send them to myself or Bruce or Richard as necessary. And then if you make a mistake, we're just looking to find if there are any gaps in training, that type of thing, not a sort of big brother watching you scenario. We just want to know if there's anything we can do to stop the mistakes being made. File closing, really you just need to try and get rid of as much unnecessary paperwork in the file as possible. You don't need to keep 10 copies of track change documents, that type of thing. Also think about now the client information, what we don't really need to keep. Please do fillet it and get rid of it. That includes also not just the physical file, but the file on the Word system as well. Try and just get rid of as much information and stuff that we don't really need as possible. Document labelling, this came up in the Lexcel assessment, is to try and put a footer on all the documents so that we can track them back to the client letter, rather than them just going around the offices and potentially getting lost. Please also try and remember, especially in light of all the little videos that you're about to be watching, is that you need to update your development record, so you can put these on that, and any other little bits and pieces that you do, research that you do, training, anything else like that, you need to be updating your development record and plan. If you've got any questions about that, not sure what you're meant to be doing, you do talk to myself or Louise, and we'll let you know what you're supposed to be doing there. They're all in the IT folder, HR folder in the information store. A few other little bits and pieces, mostly to do with accounts, is please check SOS before you open or put a new client on the system, or a client, just to make sure that they're not already an existing client. What you'll see when you go in is that there quite often is the same client appearing in SOS with 5 different client matter numbers. So please do check first before you open another matter that they're not already on there. Also do remember that if files change from one fee earner to another, you should also check and change SOS so that the fee earner is correct. That also applies if the client changes name partway through, so they start off as a company and then change to an individual, that type of thing. You must try and keep SOS updated, and also don't forget to record the ID that you take for everyone on SOS, because that's where you should be checking first to see if we've got ID for the clients. Time recording, this is mainly for the residential conveyancers, is that please don't record chargeable time after the matter's completed. Also, TTs going out from the office, just a quick reminder that you need to get a second person to double check it and sign it off so that the bank details accounts know that they're correct. Don't send out our email details by email, fax them or post them or call people to give the details over the telephone, and equally that applies to client information and other solicitors' details, that if they've sent it to you by email, before you send any monies out you should ring them and double check that those details are correct. I think that's about all I've got to cover, so hopefully if you've got any questions do come back to me.